Abortion has been such a hot-button issue for so many that it's become a topic to be avoided. The discussions are so contentious and minds so set that in many circles it was thought to be foolhardy to even broach the subject. But ever since the undercover Planned Parenthood videos shined another spotlight on the subject,
and we are able to obtain intact fetal cadavers.
the barriers have now been torn down.
Said you know all about this.
You know, you can imagine where they would run with this, like they're selling body part, you know.
So I say, okay, what are you looking to supply today?
In 2015, the chairman of the Democratic National Committee, Debbie Wasserman Schultz, recited a common refrain of the pro-abortion activists.
We do not support rolling back the protection that the constitutional right to make your own reproductive choices established in Roe v. Wade has given to women.
It should be noted that the United States Constitution actually says nothing about abortion specifically. And while it is true that the Supreme Court ruled in favor of legalized abortion in 1973, the U.S. Supreme Court cannot write constitutional amendments, meaning women's reproductive rights are still not mentioned in the Constitution. The Constitution's preamble does promise to secure the blessings of liberty to ourselves and our posterity, end quote. It would seem that the unborn babies would qualify as our posterity, and thus are deserving at a chance for life and liberty. However, since there is no language in the Constitution specific to abortion, was there anything our founding fathers said or wrote to indicate their feelings on the subject? For that insight, author and historian David Barton.
After America separated from Great Britain and the Founding Fathers made their own brand new and unique government, they still preserved and protected the legal position against abortion. This fact was made clear by Founding Father James Wilson. James Wilson was one of only 6 founders who signed both the Declaration and the Constitution. He was the second most active member at the Constitutional Convention, and he was placed as an original justice on the U.S. Supreme Court by President George Washington. Wilson began America's first organized legal training, and he authored our first legal textbook for students in which he told law students, quote, "With consistency, beautiful and undeviating, human life from its commencement to its close is protected by the common law. In the contemplations of law, life begins when the infant is first able to stir in the womb. By the law, that life is protected," end quote. American law was clear. As soon as it was known that there was life in the womb, at that point, that life was protected by law, for the purpose of government was to protect all inalienable rights, including that of life. In the Founders' Day, they recognized that there was a right to life in the womb as soon, as James Wilson said, quote, "The infant is first able to stir," that is, when movement could be felt inside, and thus they knew for sure that there was indeed life within. But with today's technology, it is now possible to know with a certainty that life is within the womb from only a few days after conception. Regardless, whenever it is known that life was within, according to the documents penned by our Founding Fathers, at that point unborn life was to be protected under the law.
In the late 1700s, America's attitude on life stood out compared to the rest of the world. Because our founders believed the things that they did about God and nature, there was a difference between the law here and elsewhere around the world.
According to our founding documents, a primary reason that government exists is to protect the inalienable right to life, which included unborn life. Interestingly, during the time of the founders, America's position on protecting the life of a child was quite different from what was practiced in many other nations even at that time. Across much of secular Europe, it was wrongly believed that parents and not God gave life to their children. So under the law in those countries, parents had the right to take their child's life. After all, they believed they had given it. But Americans knew that the life of a child came not from parents, but rather from God. Parents therefore had no right to deprive an unborn child of its life. As signer of the Declaration, John Witherspoon acknowledged, quote, "Some nations have given parents the power of life and death over their children, but here in America, we have denied the power of life and death to parents," end quote. Because God himself gave to every individual the inalienable right to life, America's early state laws were very clear on the prohibition against taking an unborn life, such as the law in Virginia during the time of Founding Fathers Thomas Jefferson and James Madison, which declared, quote, "But if a woman be with child, and any gives her a potion to destroy the child within her, this is murder, for it was not given her to cure her of a disease, but unlawfully to destroy the child within her," end quote.
It is also true that America's feelings on abortion predate the U.S. Constitution, as Barton explains.
From our earliest beginnings, abortion was always seen as wrong. For example, for the first century and a half following our initial colonization, America was under British law, and the policy on abortion throughout that time was explained by British judge and legal writer William Blackstone, who was a particular favorite of our Founding Fathers. In fact, Thomas Jefferson quipped that American attorneys studied Blackstone with the same devotion that Muslims studied the Koran. Concerning abortion, Blackstone said, quote, "Life is the immediate gift of God, a right inherent by nature in every individual, and life begins, in contemplations of law, as soon as an infant is able to stir in the mother's womb. For if a woman is quick or alive with child, and by a potion or otherwise kills it in her womb, or if anyone beat her, whereby the child dies in her body, and she's delivered of a dead child, this was by the ancient law homicide or manslaughter," end quote.
No one today, with the possible exception of one of Donald Trump's many points of view on the subject, would favor a woman being charged with anything should an abortion occur. Instead, as during the pre-Roe v. Wade years, the abortion provider would be charged. The discussion has become so twisted, though, that now the baby and the father, for most abortion activists, don't even factor in the equation at all. As NARAL spokesman Elise Hogue put it,
very, very complicated decisions, which is why when Americans hear how complicated those situations are, that they are among the most complicated medically, they believe that the choice should remain between a woman and her doctor.
Most people would never suggest that, for instance, the choice of whether or not to fix a car should be between a woman and her mechanic, leaving her husband out of the decision entirely. But abortion proponents have no problem insisting that even when a human life and a father's child is at stake, the choice is only for the woman and her doctor. But the spin by abortion supporters continues, as with this initial paragraph from a Center for American Progress article in 2013. Quote, "If recent legislation passed in Arkansas and North Dakota is allowed to stand, it will be harder for women to get an abortion in those states than it was in New England in 1650. End quote. Doubtful, since again, the colonies operated under British common law, which made abortion illegal. Quote, "Legislators in Little Rock and Bismarck have passed new restrictions that ban abortions according to when a fetal heartbeat is detected, which can occur as early as 6 weeks into the pregnancy," end quote. You might think that a heartbeat would be a fairly good indicator of life, but apparently not, at least for the Center of American Progress. Quote, "Federal judges have blocked the new restrictions until legal challenges to their constitutionality are settled. But the 6-week deadline contrasts starkly with early American abortion laws, where the procedure was legal until the quickening, the first time the mother felt the baby's kick, which can happen anywhere from 14 weeks to 26 weeks into pregnancy," end quote. First, the procedure was not legal until the quickening. It was an illegal misdemeanor, and the reason it became a felony after the quickening is that there were obviously no ultrasounds at the time to detect life prior to the movement by the baby, or the quickening. So it was the only way to tell for sure that there was life in the woman's womb. It may well be that America's founding fathers didn't specifically address the abortion issue because they couldn't conceive of a people that would destroy the lives of 55 million unborn babies in a 43-year period of time.